What are the main differences between a revocable and an irrevocable trust in North Carolina? Hey there, my name is Ron Payne, and I wanted to share with you just a quick tip about the differences between revocable and irrevocable trust here in North Carolina. It's a frequently asked question, and I hope this answers it for you. So first, the main difference is one of them you can edit, one of them you can't. Once you have completed and drafted and you've done everything, the irrevocable trust is irrevocable. You can't edit it. You can't change it. You can't change the trustee. You can't change the beneficiaries. You can't change. If you put an asset in there and you're like, oh no, I need to get that asset back, you're not going to be able to do that unless the trustee, who you've named and can't be you, says, yeah, sure, no problem. For the revocable trust, you can change the beneficiaries. You can change the assets. You could put an asset in. You could take the asset out, etc. And so now there might be consequences for that, right? Like if you move a non-taxable asset and you change tax situations, there might be some quirks, but overall you can move things to and fro from a revocable trust, no problem. You can change who's going to get the money, you can change who the trustees are, and you can dissolve it. You still have control. It's revocable. You could just say, you know what, this is too complex, I don't want to fool with it anymore, we're done. Maybe you've spent all the assets in retirement and there's not really that much left at this point and it doesn't make sense to have a trust. Great, no problem. With an irrevocable trust, you can't do that. And there are, of course, some exceptions to that, but that's the general rule. The other huge difference between a revocable and irrevocable trust is asset protection. If you have a revocable trust, then those assets are considered yours if you're the trustee, and what that means is the IRS or creditors, if you were to find yourself on the receiving end of a lawsuit, somebody's suing you for money, the assets of the trust, so if the trust has money, bank accounts, land, etc., are assets that can be seized as part of a lawsuit. Conversely, if you have a irrevocable trust, you don't have control of those assets. You've given up control. It's irrevocable. Somebody else is the trustee. And what that means is if you get sued, or if you have to go to a nursing home, the irrevocable trust prevents you from being able to be on the hook as long as a certain amount of time has elapsed. You can't do that the week before you get sued for something, throw it into a trust and go, ha, I got nothing. No, it doesn't quite work that way. But you can, if you have it in an irrevocable trust, and then 5, 6 years, 7 years down the road, somebody comes and goes, I'm going to sue you. And you go, well, you can, but I don't have anything. What do you mean you don't have nothing? You've got a great house. Yeah, but I don't own the house. What do you mean you don't own the house? It's in the trust. And so asset protection is a great way or a great reason you would use an irrevocable trust. I hope this has helped make it a little bit more clear for you. If you have any questions, don't hesitate to reach out to us. We do free estate planning consultations here at Payne Law, and we'd love to talk with you about how we can help. You can reach us on the web at applepainelaw.com or via the phone at 336-281-6928, or follow us, like, and subscribe here on YouTube for more helpful tips. Hope this has been helpful, and have a great day.